This is FBG.Live. From touchdowns and concerts to weddings and Christmas parades. Live video production right here in Fredericksburg, Texas. Live, local, here for you. FBG.Live, capturing your moment for generations to enjoy.
Good morning, everyone. It is December 9th, 2025. This is a regular meeting of the Gillespie County Commissioners Court. Before we call the meeting to order, we're going to start with an invocation. We have Bill Lucy.
Acknowledging that you are a loving and sovereign God.
We thank you for the privilege of gathering today and for the commitment of all those who serve our county. Grant us wisdom and temperance as we consider the matters before us. Help each person who speaks to do so with sincerity, seeking the very best for our community, and give us grace to respect one another's views, even when they differ. We give thanks for the dedication of our leaders and all who labor for the good of our county. May your guiding hand be upon every decision made here today. We ask these things in Jesus' name. Amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. One Texas flag. I pledge allegiance to thee, Texas, one state under God, one and indivisible.
All right, thank you, Mr. Lucy. Is David in here? I just think somebody's got to turn down the speaker a little bit. I think it's maxed out on volume. Okay, it's 9:04 a.m. We're going to officially call the meeting to order. This is a regular meeting of the Gillespie County Commissioners Court. All members of the court are present this morning. And we've had a request to take action on one particular item related to the sheriff's office, so we will move to that item. If y'all are ready. Is that the request? Yes. Sheriff, you out there? Did you want to take action on an item up front?
So that we can get him going on the process and also get him qualified today.
So let's approve the hiring?
Yes, sir.
Okay. So we will move to item number 6, which is consider approval of promotions, transfers, payroll changes, and or hiring for positions in 6A, the county sheriff's office.
So what we're looking at is hiring, bringing on Billy Schmidt as a jailer, also / courtroom bailiff. And so what he will be coming on, it's in the stuff that I sent you, but it would be $28.37 is be his hourly starting rate. He has 17 years of experience with the Fredericksburg Police Department, so we're able to start him as a jailer at 10 years.
Schmidt or Smith?
Schmidt, S-H, yes, sir. S-C-H-M-I-D-T.
I think the volume's going too high, check.
I'll move to approve.
Second.
And that will be effective immediately.
All right, there's a motion and a second to approve effective immediately. Any other discussion? All in favor, say aye. Aye. Any opposed? That motion carries.
Thank you, gentlemen.
Okay, thank you. Okay, now we're going to go back to item number 3 and item number 4. They're somewhat related. It's going to be discussing the status of both of the proposed projects in the county and consider taking appropriate action related to same. And we have several people that have signed up to speak. Some of them I can't tell which particular project they signed up for. But before we do that, I was going to make some statements, give updates on the status of what has occurred since our last meeting related to both of these projects. So we'll start with the Rogers Draw project, proposed project in Harper. Last week, the county issued a stop work order pursuant to the county's floodplain ordinance for construction that was occurring on the site without a permit in place under the floodplain ordinance. We have received no response from Peregrine yet related to that. Melissa, did you hear anything this morning from them? Okay. That was issued pursuant to the county's flood ordinance, so Melissa Eckert was able to issue that as the floodplain administrator. When we get to the action item on item number 3, I also will I'm intending to make a motion today to shortly for us to consider taking action as the AHJ to issue a second stop work order on that project pursuant to NFPA 1.7.15 for work being done contrary to the code. We've been through this before. It's a somewhat nuanced legal interpretation to get through that, but we at this time, in my opinion, at this time, the facts support that action, and so we'll discuss that in a little bit. On the Marshall Springs project, a letter was sent to Ampere President. I'm summarizing, but essentially that letter said that no development activity can occur or commence on the project until permits have been issued pursuant to the county's floodplain ordinance. That included, I noted in that letter specifically, that included removal of vegetative matter, which I put trees and to lay it out very specifically. That's what I was talking about. That letter, I also emailed a courtesy copy of that to the project manager that's been, I guess, working on the project most closely. I have received no response from Ampere related to that notice or that letter as well. There was a question about the installation of electric, the electricity, I guess the installation of the infrastructure, the electric infrastructure for the project, and whether that would be subject to any codes. NFPA 70 has an electrical code that I would expect would be applicable to the installation of that project. If the State Fire Marshal's Office, if you go to their website concerning BESS installations, they also make reference to that same section, so I would expect that the State Fire Marshal's Office would support that position as well. There's been some questions raised about when first contacts were made between Ampere and the county. I've gone back and reviewed all my records, created a timeline. I think many other staff members and elected officials have done the same. And then Commissioner Olfers contacted Ampere to try to get them to clarify what their position was on the communication. And I will say that they, in their response, they provided what I would have considered to be a status of the project. This is for Marshall Springs. And this is from Ampere. They say the project is transitioning from an early exploratory stage consisting primarily of information gathering regarding permitting and engineering and environmental studies. During the development stage, we, being Ampere, engage with the community and obtain permits. If we were to engage in community outreach earlier in the process, we would not have sufficient information to make decisions as to the viability of the project and would not have enough information to share with the community. We will be reaching out to our neighbors, elected officials, department heads, business leaders, and the community at large in January. So I'm just trying to share information that we just received from Ampere. That's their perspective of where they are on the project and what they're planning to do as far as engagement with the community and county officials moving forward. So I have any other notes here. Commissioners, anything else y'all want to add or discuss before we proceed to the public comments? Okay, we're gonna try to. I know there's a lot of similarity between these, but there's also some distinctions, and so we're going to try to discuss these individually one at a time. So we're going to start with the Rogers Draw project, which is item number 3 on our agenda. I'm going to go through the list of people that have signed, individuals, citizens that have signed up to speak. If you have signed up and wanted to speak on the Marshall Springs project, just let me know and we'll put you back and hold you back for the next discussion, item on number 4, okay? The first individual is Robert Robach.
Yeah. Here.
Yes, sir.
Mine's germane projects.
During both?
Yes.
Okay, all right, you want to go ahead and speak now? You can.
Yeah, I can.
ROH.
BOCK.
Go ahead, sir.
Okay, a little about myself. I retired from the U.S. Navy as a CW04. I was a former ship's material officer, machinery division officer, repair division officer, main propulsion assistant, a damage control assistant, which is the ship's fire marshal, a chief engineer, and as a civilian, I worked for BAE Systems and L3 Communications, the Advanced Systems Division, as the Environmental Health and Safety Officer for both of us. I live on Wildlife Trail with my wife, about 1.5 miles from Marshall Springs. She's a retired naval officer in medicine. She spoke last time. And, I have to echo her sentiments is Texas means a great deal to us. Fredericksburg means a great deal to us. It's a Navy town. At least that's what we think. We love it. We love the people here. But we got a new challenge. Fires. A U.S. Fire Service recently needed 24,000 gallons of water to put out a vehicle fire. That's an electric vehicle fire in a parking lot, so it was isolated. Studies show that it may even require more water than that to put out just car fires. If you take a gasoline-powered vehicle, an ICE, internal combustion engine vehicle, and start it on fire, it's going to get about 1900 degrees. A Tesla gets 9,000 degrees, or 5,000 degrees. And you can normally put them internal combustion engines fires out with about 1,000 gallons. So the electric vehicle is going to use 40 times more water to put out, or at least control, than an internal combustion engine. And I'm sure some people have seen car fires. Now, 40,000 gallons of water that's used on that fire is now contaminated water. And that's not a best. That's one single vehicle. Several fires have occurred at stationary storage facilities. The 250 megawatt fire in Gateway Energy Storage Facility in San Diego, California, burned for over a week in 2024. Now, the fire risk and consequences for light EVs, electric scooters, and bikes are much higher than that for passenger cars and supposedly for bus facilities. However, there was over 500 fires, lithium-ion battery fires, resulting in 36 fatalities between January and July of 2023. Lithium-ion batteries also pose a risk to transportation. You can't load them on an airplane and fly. Three incidents suspected of being caused by lithium-ion batteries as cargo resulted in loss of aircraft and crew. While a major lithium-ion battery fire has not yet occurred in a manned space flight, NASA centers have seen prolonged use without incident, but the fire risk persists even at the end of the battery's life. December 3rd of 2025. Okay, that's just a few days ago. The results from the Moss Landing fire in California haven't been released yet, haven't been determined. They're still researching. That 300 megawatt facility was the largest battery facility. It was owned by a Texas corporation. It caught fire January 16th of this year and burned until January 18th. Supposedly it was out. February 18th, it started again. So that's a whole month that it just was kind of like dormant. A study from researchers at San Jose State Marine Laboratories estimate 55,000 pounds of heavy metals was dumped into the soil near Elkhorn Slough, which runs just north of the battery energy site. That is the first independent study done of the fire's result. Health and safety concerns from residents near the plant and in Santa Cruz County, which is the next county north, I think, have only continued to grow following the incident. Moss Landing residents filed a lawsuit against Vistra shortly after the blaze, alleging the company failed to implement adequate fire safety measures. That's a Texas corporation. We're dealing with Ampere from Singapore. The safety measure reported people having bloody noses, skin rashes, and lung problems. A lawsuit's been filed, and it's gained support from Erwin Brockowitz. In a recent study led by Ivano Aleo, a marine biologist at the Moss Landing Marine Laboratories, is the first independent study of the fire and its impact published in a scientific journal. He estimates that roughly 2.2 million to 3 million pounds of burned battery materials could have been carried into the smoke plume. Where does that go? They found about 2% of the chemicals released in samples in that Elkhorn Slough. The samples were linked to the fire because the nickel to cobalt ratio matched the chemical discharge from the battery fire at Moss Landing. Texas A&M in 2024, along with research partners, conducted a series of tests lithium-ion batteries on their impact on first responders and their personal protective equipment. The researchers also measured the effectiveness of different cleaning methods. All the tests were conducted at the Southwestern Research Institute facility in San Antonio, Texas, under the direction of Dr. Ahmed Khalek, the Institute engineer and principal investigator. The lithium-ion batteries used in the test were similar to electric vehicles such as scooters, hoverboards, and smaller consumer products. They forced the batteries into an overcharged state, and while they did this, the batteries were confined in a blast chamber. The stuff they tested, the SBCAs, and the clothing and different swashes of materials, tested 24 heavy metals and 75 semi-volatile organic compounds. The tests concluded that the thermal runaway fires are an extreme emission event, releasing toxic gases, which are IDLH, immediately deadly to health and life, and particles that exceeded OSHA permissible exposure limits. During the tests, it ranged from 12,000 to 17,000, more than the EPA ambient standard limit for particular matter. High concentrations of lithium, nickel, cobalt, manganese, copper were detected during each lithium thermal runaway event, with lithium being the most dominant. Traditional NFPA 1851 water-based cleaning of the PPE removed about 99% of the metallic particles in the gear. Liquid CO2 cleaning removed 99.8. Some of the semi-volatile organic compounds remained in the gear after the water-based cleaning. So the conclusions, these tests quantifies the chemical toxicity of lithium-ion batteries that go into thermal runaway. The contaminants that first responders are exposed to when responding to these events. This confirms that the global lithium-ion battery use is an emerging hazard. It's emerging so quickly that they haven't had time to regulate. This must raise awareness of the human health and environmental risks associated with lithium-ion batteries. We must ensure that our first responder community has the resources, which is training and equipment, and that isn't free, to shape their response protocols. such as apparatus positioning, cleaning efficiencies, and develop a standard operating procedure and guidelines to respond to these fires. And that goes back to this 40,000 gallons of water to put out one fire. How many thousand gallons is it going to take to put out a BESS? And where are you going to contain that? I'm sorry. The other thing is, we all, and I mean we all, have to educate ourselves about greenwashing. Greenwashing is becoming an eco-friendly byproduct in recent years. If you ever picked up a product because the package said natural, or it looked recycled, or it doesn't use fossil fuel, you may have been a victim of greenwashing. Far too many corporations run warm and fuzzy ad campaigns while still causing massive damage to the planet. Knowing how to spot greenwashing will ensure that deceptive brands don't walk away with your hard-earned money. My wife brought up the Hippocratic Oath of do no harm. Clearly, the concept of doing the right thing will never make any headway with people who view such framework as being a direct contradiction to maximizing profits that they place above everything else. Instead of these companies and their decision makers have to change their behavior, they must be prevented with the consequences that directly threaten those cherished profits. Groundwater. Does groundwater move? Yeah, it moves up and down, sideways here and there, and it's usually pretty slow. Frequently as few as a few feet a year. Although it can move several feet per day in more permeable zones, groundwater can move even more rapidly in karst aquifers, which is soluble limestone, which I'm afraid Texas sits on it, where the fractures and cracks have been widened by the action of groundwater to form sinkholes, tunnels, or even caves. Are there any laws that or programs to protect groundwater? To enable effective management of the state's groundwater resources in areas where critical groundwater problems exist or may exist in the future, legislature authorized the Texas Commission on Environmental Quality and the Texas Water Development Board and the Texas Parks and Wildlife Department to study, identify, and delineate priority groundwater management areas and initiate creation of groundwater conservation districts within those areas. Crucial groundwater problems are defined as shortages of surface water or groundwater and land subsidence resulting from the withdrawal of groundwater or contamination of groundwater. The PGMA, which is again that priority process provided in Chapter 35 Texas Groundwater Code, implemented by the TCEQ rules that outline procedures for the designation of the PGMAs and addresses issues related to the creation of groundwater control districts are contained in chapters 29 or 293, 294 of Title 30. This is really mind-boggling. Now, the PGMAs that have been designated in Texas include parts of Reagan, Upton, and Midland counties, parts of El Paso County, all of Bandera, Blanco, Gillespie, Kendall, Kerr, and parts of Behar, Como, Hayes, and Travis County, which is basically all hill country. That's this whole area. The Water Code Section 35.008 designation of the priority groundwater management area may not be appealed, nor may it be challenged under Section 5.351 Judicial Review Commission Act or Section 2001.038 Declaratory Judgment of the Government Code. These PGMAs, the priority groundwater management areas, the effective director administrator shall meet periodically to gather information by the water development boards in those areas that are experiencing or expected to experience problem within the immediate 50 years. Shortage of water, surface water or groundwater, land subsistence resulting from groundwater withdrawal, and etc. When the rain falls, it seeps deep into the earth, filling cracks and crevices, spaces of the aquifer. Nearly 40% of the United States rely on groundwater for drinking. Some folks in rural areas, like ours, it's their only freshwater source. Groundwater gets polluted when contaminants from pesticides, fertilizers, industrial waste leach from landfills and septic systems and wherever into the aquifer, rendering it unsafe for human use. Now, to get rid of groundwater contamination can be difficult to impossible, as well as costly. Once groundwater is contaminated, it can spread far from the original polluting source. Now, the United States Environmental Protection Agency, responsible for federal activities relating to the quality of groundwater, the Safe Comprehensive Environmental and Response Compensation and Liability Act, the Superfund, authorizes the government to clean it up and then raise our taxes to pay for it. Federal Insecticide, Fungicide, Rodenticide Act authorizes the EPA to control the availability of pesticides which can leach into groundwater. The Toxic Substance Control Act, which authorizes the EPA. This stuff goes on forever. I mean, and it really is boring, but it's important. That's what we, the people, have had our government put in place to protect us. The Clean Water Act. Okay, now, in my country, you can ride for days and see no groundwater. Why, I've lapped filthy water from a hoof print and was glad to have it. You really don't know what discomfort is until you have nearly perished for water. I know some of you have seen that movie, True Grit. And Rooster, of course, says, if I ever met one of you Texas Waddies that says he never drank water from a horse's track, I think I'll shake his hand and give him a Daniel Webster cigar. I don't want a Daniel Webster cigar. I don't want to drink the dirty water. My wife had some very, very good photographs on results of the health thing. The only one I could find that was anything is this one. And that's what we're all going to be doing. And this is Bernard's dehydrated water. You simply empty a can of this into a gallon of fresh water and stir until it dissolves, and then cool and serve it. That's where we're at. We're all going to be looking for Bernard's. That's all I've got. Sorry. Very good. Thank you, Bob.
Will Houston, you want to, is that you, sir?
Yep.
Did you want to speak on an item?
No, I didn't mean to sign up for that.
Okay.
But sorry.
Did you, I mean, I've got the form, did you sign up to express opposition, is that?
I don't read well sometimes, I guess.
Okay, all right. I'll move on to the next one. Mr. Strange? Scott Strange?
Put my eyeballs on here. I'm going to read a letter from a lady, a citizen, who couldn't be here.
Mr. Strange, I'm sorry, you wanted to speak on Rogers Draw, I'm assuming?
Both of them.
Both, okay.
Both. Excuse me. She couldn't be here because of mental illness, but she wanted us to read this letter to you of mentioning her concerns of both of these types of facilities. It says, for decades, communities have watched large communities move into rural areas with promises of investment only to leave behind environmental damages, infrastructure strain, financial burdens. Now we're facing the same threat. Residents comply with every state and county requirement, water permits, sewage permits, environmental standards, yet the state is offering exemptions and incentives to corporations while leaving residents unprotected. This imbalance must be addressed. If this project proceeds, the company must be required to permanently hire and train local workers, compensate the community for any property value losses, increased insurance and increased taxes, fund necessary infrastructure upgrades, including electrical transformers, emergency response capacity, including equipment, staff, and training. Utilize local hydrologists, environmental experts, ensure groundwater, surface water, and soil protections, support wildlife safeguards, and meet strict noise and dark sky standards. We also request complete transparency, public access to all permits, disclosure of future plans, especially regarding data centers and cryptocurrency operations, and a clear accounting of who will receive the profit and energy produced. We are asking the state and this county to protect its citizens, not just its corporate partners or land or water or communities deserve safeguards, accountability, and respect. Thank you. This is from Mrs. Linda McClure. And to follow that up, it was just recently passed in the House, Texas Government, Chapter 103, HB 3809, which requires these companies to decommission properly these battery energy storage and solar facilities so that when they're done on their 10, 15-year lifespan, they don't just leave this stuff here for us to deal with and we have to pay for it. Thank you.
Jay, do you want to speak on one or both?
I can, mine's specific to Marshall Springs, but you guys probably want mine before Esther's. If I'm being completely
What did you say? We're doing Rogers Draw right now.
You can give it to him after we cover it. So I apologize, this is gonna be slightly out of order, but, good morning, guys. Y'all doing all right today?
Good morning. Yes, sir.
I know I gave you guys an easy one last time, but this one's going to be a little bit tougher, and I apologize in advance. So you guys told us to get the word out, right? We've been working hard on that. For those who don't know who I am, my name's Jay Choquette. I'm a head coach at War Room Jiu-Jitsu and owner, but I'm also co-founder of the nonprofit that many of you have seen the flyers for FightBestTexas.org. It's a nonprofit that we formed here in our community to assist our commissioners and assist our community in the outreach and awareness, as well as directly help fund some of the legal fight that Esther and Bruce and some others have led before us in order to try and make these things, get these things killed. So today I've got 2 comments and a question. First comment is about Ampere and their public engagement strategy. They specifically have said, and online and to you guys, that they have to wait till a certain part of the project before they do community engagement. That's not by mistake. This is a common practice that we see from all of these companies across Texas. They come into these, as you specifically said, Judge Jones, they come into permitless, unincorporated towns all across Texas, and they start doing community engagement after they've already built them. They say, hey, I'm going to be a good neighbor after I put poison in your water, in your land. That's when they do community engagement. And they have the balls to tell us that they want to be good neighbors. Make no mistake about it. These guys are not good neighbors. They don't even live here. They're not our neighbors. They're taking advantage of our neighbors that need the money in order to endanger all of us. This is death for dollars. That's what this is. Make no mistake about that. So just understand that that's a purposeful strategy. It's not by accident. So there's a reason why they haven't engaged with us until they were forced to, which they have. You guys said get the word out. Thank you very much for the letter that you guys sent out to Ampere and the Marshall Springs Project. We publicly announced that last week, and we announced it among many places in the Fredericksburg, Texas Community Bulletin Group. As of this morning, that post has 867 reactions, 178 comments, and 118 public shares. We're getting the word out. But something interesting happened with this post. Because of that letter and the others that we are pursuing as far as legal against the Fluids and Ampere, we specifically called out the Fluid family. I'm not in the habit of harassing my neighbors. I believe my neighbors can do whatever they want with their property until they endanger the lives and the families of those around them. So we specifically called out both the Fluid family, Carol Johnson, who is AKA Carol Johnson Fluid. We specifically called out Sharon Fluid, who is on social media as the wife of Nelson Fluid. We specifically called them out. But there's something funny happening because they've not responded to us. Not once, nothing. We suspect that that's because they're probably under another common tactic of these guys. They're under NDAs, strict NDAs, so that they can't say anything. But you know who has been saying something? A gentleman by the name of Kenny Gunter. Does that name ring a bell for any of you guys? Kenny Gunter, for lack of better terms, and please pardon my language, is this douchebag right here. He's the director of land acquisition for Ampere Energy. He's the counterpart to the gentleman that you guys talk to all the time, Rick Hamilton, who's the director of project management. Interestingly enough, Mr. Kenny Gunther decided to join our Fredericksburg, Texas Community Bulletin Group, and he has plenty to say on behalf of the Fluids and Ampere. He's been combative. He's been disrespectful. He has pushed us off and treated us like a bunch of dumb hicks. He's done everything but say that. He's even gone so far as to say that he's a jiu-jitsu guy and he's happy to come see me in person and roll about it with his veiled threats. These are the kinds of things that these guys are saying, and this is how they're acting towards us. And they say they want to be good neighbors. No, they don't. They're here to rape our land and our resources for their profit. But that leads me to something that I need to ask a question about, and it's unfortunate. On October 27th of this year, 2025, in this commissioner's court, I specifically asked a question of each of the commissioners here. And I asked when specifically you guys each found out about the projects in each of y'all's districts. Do you guys remember that conversation? And Commissioner Olfers, sorry, but I specifically asked when you guys found out. And do you remember what your response was?
Yes, I do.
What was that?
I found, and I'll have to correct that, because I was targeted, or not targeted, I was sent with a question that I was not prepared for. And I was made aware by Tim Lindbergh. I looked it up since then.
Okay.
And it was back somewhere in January of '24. He had talked to me and Commissioner Weinheimer in the hallway and just mentioned it. That was not an engagement. It was not. It was just that he said they had inquired. That was the first time I met him. The first time I had direct contact with any of them was September 6th. I looked that up. I got an email September 5th with Melissa Eckert to have a meeting September 6th. That's the first time I had a direct contact with them.
Of 2025?
2025, yes, sir.
Okay. So Mr. Kenny Gunther says otherwise.
And I have, that yesterday is the first time I've been made aware of that name. I contacted Mr. Hamilton to say, who is saying his name?
Yeah.
And they deny saying my name. Now, if they did or did not, I searched my computer for any name related to any close to that, and it is not there.
So I actually have screenshots. He did not specifically name your name, but on this public post, he specifically said, and I'll let Scott hand them out for you guys. He said, additionally, we've been in discussions with the county as early as 2024, April 2024. And then he also said in a separate statement, for clarity, we've been in contact directly with county engineers and other parties, aka in the county, since at least early 2024. So an Ampere director is directly saying that he's spoken to our engineers and our county officials as early as April 2024.
Did it say county officials?
It literally says, it literally says any conversations, and he says directly with county officials. He said in discussions with the county as early as April 2024, any conversations with county officials prior to that, he said he can't personally speak to because they had acquired the original lease. But this guy is specifically stating in a public forum that he has spoken to you guys into our engineers as early as then. So
I can say with confidence, I have never spoke with the man.
understandable. And like I said, hey, I'm here to help you guys, right? And I'm not trying to point fingers or be combative. I'm just trying to say, like, this is what these guys are publicly saying in our community, and it directly contradicts what you guys are saying. So we just need to figure out how we can reconcile those discrepancies and get to the bottom of this, because they're saying otherwise. So, and like I said, I'm not trying to be combative at all.
I would say this, Jay, is that you just got to be talking about how much of a scumbag they are and all that. So now
Agreed.
You're believing them over what we have?
Oh, no. I'm not saying that at all. And please, that's what I'm saying. Please don't think that I'm coming at you guys. I'm just saying that these guys are saying obviously something different. And I do, and don't get me wrong, I absolutely believe that these guys are scumbags. I believe that they will say or do whatever they need to do to try and get their way and do what they want to do. And I believe that that would include trying to take advantage of you guys too if they can. And clearly all of us too. And so I want to make that clear. I'm not trying to point fingers at you guys or anything. I'm just saying that they are outright publicly stating differently from what you guys have said. So, gentlemen, thank you very much for your time.
Jay, we've done some internal investigation, if you will, trying to track down any communication with Ampere back as far as we can find anything. And we did discover an email from April in 2024 that was sent to Jay Alvarez at Ampere. And we can't figure out what it originated from because it's not a response to an email, so maybe they called. But the response was essentially our boilerplate that we send when somebody inquires whether there's any zoning or any regulatory oversight in the unincorporated parts of the county. So it's basically a boilerplate response that says Gillespie County does not have any zoning districts or building permits in unincorporated parts of the county. It goes into talk about our subdivision plats, our manufactured home rental applications, floodplain development, right-of-way permits for driveways, and septic permits. There's nothing in there indicating that it was related to any kind of solar or battery project. So, the April 2024 date, it seems to correlate with this date that maybe they called and asked for, just sort of an exploratory, like what regulations apply outside the city in an unincorporated part of the county. But it doesn't, the county's correspondence doesn't indicate that it was related to any type of particular project. And so I think that if that's what he's alleging or alluding to, I mean, I wouldn't consider that coordination or cooperation or anything like that. It maybe was just an initial inquiry as to regulations that exist in unincorporated parts of the county. And we get those very frequently from anybody that wants to develop, from outside the county that wants to develop. That's why we actually have a boilerplate response that we send them, and this is that boilerplate response. And so it does appear that there was an email sent from the county engineer's office based on that inquiry to Ampere. I think it's being mischaracterized by Ampere as some sort of, coordination or cooperation or start of the development process, because I mean, it doesn't appear to be that. Ampere's response, Commissioner Olfers contacted Ampere yesterday because of this, issue, and we didn't think that it was being portrayed accurately, I guess, by Ampere in the public.
I aptly described the guy.
And so they indicate that the second meeting was in September 2025, after the initial contact, which was a meeting I think that Commissioner Olfers was alluding to. But we did get a filing in August related to the Marshall Springs. It was their initial filing for the development permit for the floodplain. But in between this email we sent on behalf of the county in April of 2024 and that initial filing in August of 2025, we can't find any other communication with them. It does appear, I did find some EDC, Economic Development Corporation notes from Tim Limberg that he had some communication with the Save Our Scenic Hill Country group that they had been monitoring ERCOT. I think it probably was primarily for wind farm purposes as opposed to this, but they had identified some new projects, including this one. There was not really, it was mostly just like a notification. It was Tim's note saying he had heard this from them, but I think that given when that occurred, obviously our perspective on these is different than it was then. This was before Moss Landing. It was before this had really kind of reached a public, had gotten any public momentum and awareness. And so, but as far as direct contacts, that's the earliest we could find was that one email. So I'm just trying to put everything in context. I mean, I think that I'm assuming or speculating that Mr. Is it G-U-N-T-E-R, I think is his name, Gunter.
Is his name, yeah. Yeah, he's so transparent. He doesn't even put his full name properly.
It's K-N-N-Y-G-N-T-R is how he has it on here.
Yeah. Super transparent.
I'm assuming they must have some sort of project management, and they saw that initial email contact in April of 2024. But I mean, we can give you this. I mean, it's a public record, but you can see it's very, it's a very dry response to a basic inquiry. So I'm just trying to give all the information we were able to understand and find based on this issue. Anything else y'all want to add on that before we move to the next speaker? Okay.
Thank you, guys.
Is he still engaging on Facebook since?
I think after the rest of the community started giving him a proper verbal lashing for the last couple of days, I think he tucked his tail and went back to his hole. But that's the second time that he has been openly combative and disrespectful outright of multiple members of our community. So I already let him know that we're not just coming for this project. I'm also coming for his job personally because he's pissed me off.
Okay, Bruce?
I yield my time to the individual here. She has to go. You have to leave at 10. Go ahead.
Ma'am, did you sign up to speak?
I did. My name is Kathy or Kathleen Bush.
Yes, ma'am, go ahead.
Hi. I didn't formally have anything to say, but when I found out about this, I wanted to come. Please excuse my emotional. I'm here because on March 15th of 2025 this year, we had a wildfire called the Crabapple Fire. I think some people might be aware of that. It isn't the first wildfire we've had in Gillespie County in recent years, but this one was very devastating in many ways. I found out about it when we had just left our property. We had flown out for a reunion. I got a call that said there's a wildfire and it's crossing 16. Within an hour, I got another call. It's at your property. Within a little while, I had lost my house, my barn, everything in my house and my barn, my land, all my cars, and all my animals. They're trying to say that this is a safe project. They're trying to say that there won't be any problems with it. I'm here to say that there would be. Some of my neighbors almost didn't make it out. They said if we had been there, we wouldn't have made it out in time. The fire was that fast. They talked about the water damage. Yes, there would be water damage. There would be land damage and animals lost. But mostly there would be lives lost too, because we do not have the resources to fight these kind of fires. We live in an area of volunteer firemen, very dedicated people, but they're not professionals and they're not there every moment, and these fires burn hard and fast. If there's any way we can fight this, we need to, because our land and our people are worth it. And they won't be after this. Thank you for your time.
David Nash.
Good morning. My name's David Nash. I'm Precinct 2. I wanted to elaborate a little bit on this gentleman's discussion about the emergency response. There's an emergency response handbook. It's a 2024 edition. And in it, there's an orange section in there. And they have all the hazardous materials. Lithium-ion batteries are one. And so I went through that, found the section there. And there's a statement about evacuation, and it has to do with 500 meters radius evacuation from the battery systems. And well, all of those, most of those hazards in that orange section have that kind of thing. But lithium ion had 500 meters evacuation for the emergency responders. That's our volunteer fire department. And that 500 meters puts the K through 12 school in play. And so I would hope that they would take exception to that and evacuate the kids, of course. But the reason it's like that, there's two other hazardous materials in there that have that stipulation with different distances. And one of them is explosives, and the other one is ammonium nitrate, which is an explosive. So they kind of put those three explosive categories, did a separate thing just for emergency responders. And they would have to be in hazmat anyway. We've already talked about the things that they have to get close to these. So anyway, I was here to talk about specifically, I've been working with Menard here lately, and their Menard Best is as close as possible to that substation outside of the city limits of Menard, so unincorporated area. Now, I also understand that other community members in the unincorporated areas have been contacted by the company about their properties
In Menard, sir?
in Menard County. Yeah,
We're talking about Menard.
yeah. I don't know all the specifics, but I know it's more than a couple. So anyway, they were looking around for different properties as well. And so the reason that got me to thinking, I looked at the ERCOT report, and on all the standalone buses, 1/3 of them are taps. So they tap between substations, which means that, there are locations that are fairly remote, especially if it's tied to like a solar farm or something like that, because that would be, you just wouldn't find that much room unless you had a large property. So that just gets me to thinking if this company has ever considered other properties or just going straight to the solution to get as close as possible to substations, where the Harper is one. So, bad neighbor. So that's all I had for Harper. Thanks.
Judge, I would like to clarify, if anybody wasn't aware, we have spoken to multiple other ranchers here, and they have specifically approached other ranchers here as well. We know for a fact that they have, the Saltemeyers being one of them. So we know that they are actively approaching others here.
Okay. I do recall that, related to Peregrine, that they had identified a number of sites initially, and then I guess they pare them down based on, probably availability and location and, feasibility.
Looks like Jay got it.
Jay, is this yours, Jay?
Did you sign up twice?
The guys might have signed it, they might have signed up for me twice, so. I mean, I am allowed that, but not twice.
All right. Bruce, did you want to make a comment, or did you just want to forego your comment?
The only, hello, Bruce Knightsky, Gillespie County. The only comment I would like to make is to kind of emphasize on what Robert had said, is that the EPA standard for particulates is the EPA PM10. It goes all the way down to 10 microns, absolutely tiny. These 10 microns that go deep in your lungs. So that's the particulates that we're talking about, and I believe he said 17,000 times the limit.
Mr. Schneider?
Good morning, everyone. To say that the legal filings have been enlightening is putting it mildly. Imagine our surprise to read the county's filings, specifically Judge Jones' sworn statement and emails. The county engineer, Melissa Eckert, and Commissioner Keith Cromer have been coordinating with officials from Peregrine since December of 2023. That's a full year before the residents of Harper were informed during a public presentation. All the while, Commissioner Cromer, you've suggested that you only knew about this project a week or so before the presentation. Yet at that presentation, you told people we were getting a new fire station and a new brush truck. Okay? Might I please remind everyone of those citizens present today, the Harper citizens have raised $65,000 for our legal defense fund. Our expenses are over $100,000, and we haven't even had our hearing in January yet. Furthermore, several of us have spent more than 1,200, 1,500 hours over the last year researching, presenting, providing this court with tons of documentation to tell you how to fight these projects. Yet, we've been told every time there's little you could do. Shockingly, on page 4 of the county's own filing, It specifically states that NFPA promulgates regulations enforced by the county. We have told you that for over 10 months. Commissioner Cromer, could you please explain why you and Ms. Eckert have coordinated with Peregrine since 2023 and have said otherwise?
I have not coordinated with Peregrine. I have not had any conversation with them other than their representatives when they first initially contacted me. And then you and I had gotten together, and before any kind of discussion, I mean.
So is that why the email shows that you were in conversation with them since
It's
since 2023?
I was CC'd
That, yes, you're CC'd on it. And that is your responsibility to read your emails and to be informed as a commissioner.
Yes, ma'am.
That was a year before we were told. I'm going to ask you straight up, did you sign a non-disclosure agreement with Peregrine Energy or any other entity?
I have not signed anything, and I have been very vocal from the very get-go that we do not want you here. I publicly told them that. I've stood in front of the news cameras and professed that we do not want you here.
So you're saying you did not sign an NDA?
With them?
Did you or did you not sign a non-disclosure agreement with any energy company, a representative of a subcontractor, or anyone
I
else?
have not done anything.
Yes, no.
No, I have not signed
Okay,
anything.
thank you.
Yes, ma'am.
We are finding out that all of these counties across the country or across Texas, their representatives have signed non-disclosure agreements. That's quite shocking, and it's also illegal. Okay? Have any others, Judge Jones, are you aware of any NDAs that were given to any county officials, any departments, or anything?
I have not heard of any NDAs even being discussed by Peregrine or Rampier or anybody.
Okay. Commissioner Weinheimer?
I've never been in touch with any of them.
I know, I'm just saying, have you heard about any NDAs?
I have never heard of an NDA with a county official, and anybody wanted to go do the project.
Okay. Commissioner Olfers?
Same, no.
Okay.
Same. No.
Okay. We have to ask that question. There's a lot of things. I mean, you have to appreciate the fact what we have done over a year, the money that has been spent, the effort that's been made, and we are grateful that you all have finally joined the litigation, but it has come with a lot of pressure by us to you to act. The fact that we told you back in June construction was happening on the site, and specifically, Ms. Eckert, you told us not. I actually have a list. That Peregrine submitted in their discovery. And it's very specific, starting from May 16th, going all the way to November 15th, okay? All of the SWIFT inspections, the asbestos removal, the LCRA subcontract start. There's also on June 16th, an LCRA notice to permit. There were permissions given, approvals given, yet we were told no construction occurred. I mean, this is what the litigation brings out. It is things that have been purposely or accidentally, however way you want to say it, not told to the public. And yet we've had to pay for all these legal fees. And there's never been one word from any of you to say thank you for bringing us all this information. There's been nothing. In fact, all we've gotten is harassment when we've asked questions. Okay?
I'm sorry, the date you were just discussing, what year was that in? About the permitting, was that this year?
That was this year, in June. We told you. We told you there was a TCEQ large construction permit. And Ms. Eckert insisted no construction took place. Yeah, you know what? You've said that all along. Yeah, and guess what? Why is the county now suing and issuing a stop work order?
So you have a new version of the floodplain development ordinance.
And why did you change it in the first place?
Yeah, I agree that there should be.
You sat in our meetings in January and February of 25, acting like this was the first time you'd heard any of the discussion about this project. That is so deceitful. Are you proud? I wouldn't be. You don't believe that's true? You acted like you had never seen this, heard this, any of it. And yet your emails condemn you. I have nothing further.
Okay, that's all the comments I have, or all the public forums I have that have signed up for the Harper Rogers Draw project. Is there anyone that signed up to speak that I did not call on that item? And the only remaining sheet I have is for Mr. Nash for Marshall Springs. Is there anyone else that signed up for Marshall Springs that has not had an opportunity to make a comment?
Yeah, I'll be brief. Let's see. I wanted to elaborate on the House Bill 3809. Okay, it does have financial assurance clause in there, but it only applies in 15 years into operation. So the last 3 best incidents, or fires actually, in the United States, all 3 were in the United States, 3 different states. And one of them was 4 years into operation, second one 4 years, third one 3.8 years. So if that happens, there's no financial assurance. It's not required until 15 years into operation. Okay, so with that, Marshall Springs has a 30-year lease.
It's 30 years.
Just got that. So
Plus two 10 extension options, 10-year extension options.
okay, so the facility, the battery set that probably won't be there in 30 years regardless. But anyway, that's applying to Harper. So also in the GIS report, and when you take the solars out by themselves and look at them, well, only a little less than half of them actually have a BESS. They're just tapped in normally to in between substations, like the one in Marshall Springs. So my question is, why did that's half of them. So I would think that would have been a consideration too. These transmission lines coming off of the BESS are no different than the other 138 kV transmission line. So it could be a distance to the substation that's further, or a direct tap into that substation. These 2 substations, I believe, are in Gillespie County, but it had a real long description in the GIS report, and it said a new point of interconnection, and it also said 2 lines that loop back to the new point of interconnection. Totally different than the description of others. So I would also be concerned about I would want to get the electric one line drawn and review that for sure, because there's some additional equipment probably involved there. And anytime you add any kind of equipment, you just add any, more reasons for faults. So I really don't know that much about it, but it did raise a question. That's kind of a drawing that you would expect for them to send you, electric one-line drawings. I think that's it. Thank you. Do you have any questions?
I have a question for you, David.
Sure.
Does that House Bill 3809, does that give us a premise? I'm not a lawyer, and I would obviously defer to Sarah, but does that not give us a premise to potentially hold them accountable for the full force of the decommissioning cost up front as part of the permitting process? And similar to what like Van Zant and other counties have done, where they're saying, hey, you gotta, it's a $650,000 non-refundable permit, right? Or something, along those lines. Is that not something that we could potentially consider? Is they're like, hey, decommissioning of this structure is, $5 million. We're gonna need that up front as the permit to ensure that we can hold you accountable for that.
That's a good point, and part of the NFPA 855 is, deals with the decommissioning plan. So you get the decommissioning plan and you ask that same question, or a variation of whatever you think that you should get for financial assurance. I recommended when I testified on that bill to make it before commissioning, make that financial assurance before commissioning. And these things get damaged during shipment, during construction and all that. But, you could go even sooner than that, but you kind of have to have, I think that's a pretty good point, before commissioning. But once it hits that land, it might be something you want to have as soon as that battery. As a matter of fact, that would be a stop for having batteries even in there until you get a decommissioning plan that has a financial assurance. It's just my thought.
So we'll have, go ahead.
I don't have anything else.
So there's actually so now there's a statute that applies to solar complex decommissioning and then the battery energy storage decommissioning. There's two separate sections now. And so, like Marshall Springs could potentially need both, one for each type of project or each phase of the project. It's been a little while since I've looked at this, but my recollection is that it requires that there be in the lease for the project, so it's really between the developer and the landowner or the lessor. But we have discussed and intend to incorporate that into our essentially approval process if we ever get to that point, because that's one way to assure that they're compliant with state law regarding the decommissioning plan. So, what type of financial assurance is provided? I mean, there's probably options. It could be bonding or cash, or there could be probably various ways that they could meet that obligation. But we do intend to incorporate that into our review and approval process if we get if we get to that point, that to assure that there is plans in place for both phases of the project. And so the solar decommissioning statute has been in place for a while, and the battery energy storage is a new section that was just added by the legislature. Whether they'll be forthcoming with that information or not, I don't know. But we intend to investigate that as part of the overall. It's one of the steps in our multi-step approach to this deal. So.
Is there potential to also put discovery costs in this permitting process, right? Because, think of all the time that all of you have already invested in this, right? Even just dealing with us constantly. I would imagine there's a ton of man hours in Ms. Eckert's efforts that she's had to spend all the time and energy she's had to put in this, right? Like, I think that there should even be fees as part of this, right? Just for all the discovery we've had to do, just to inform ourselves and you guys along this way. I think there should be, for them to even apply for a permit, there should be restitution, I feel, for all those efforts and all those finances that everybody in this community has had to spend on their behalf while they sit snug up in their offices, while we're all out here fighting it and they're just sitting there.
I will add that the two statutes that were being discussed about the decommissioning, even though it's supposed to be between essentially the landowner and the developer, there is a section in there about, it says any party that's negatively impacted or affected by this can bring action. And so I think that's another way that we could potentially bring, as the county could bring, even though we're not a direct party to that agreement between them, related to the decommissioning. It may be another avenue for us to litigate on that issue. It gives us a direct express statement that we could potentially seek judicial action related to that, just to that issue. And so that's just one of the things we're kind of we've got on the menu, so to speak. But I just want to make you aware that we do discuss that. We're not planning to just kind of sweep that or not pay attention to that particular issue. It is on our radar.
Thank you, guys.
All right, thank you, Mr. Nash.
You're welcome.
Did anyone else sign up that has not had an opportunity to speak? I believe that's everyone, just making sure. Okay, let's go now specifically to item number 3, which is related to the Rogers Drive Battery Energy Storage Facility in Harbor, and consider taking appropriate action related to that. As I mentioned earlier, I tend to make a motion today related to that. Anything that y'all want to discuss before we do so? Or Sarah, anything that? Okay, so related to the Rogers Draw project, I'm going to make a motion that the County Commissioners Court as the AHJ issue a stop work order pursuant to NFPA 1.7.15. Specifically, the condition that work is being done contrary to the provision of this code being NFPA 1. The analysis on this is a little, it's not straightforward. The term work is not defined in NFPA 1. The definition for construction is not defined in NFPA 1. However, the NFPA does provide that if there is no definition included, then the Merriam-Webster's dictionary shall be the source of the ordinary accepted meaning for those terms. Work is defined as a specific task, duty, function, or assignment being part of a phase of a larger activity. And construction is something built or put together. Last week, two different county, I'll say county, not officials, but not elected officials, but staff members have presented evidence that there has been construction of a utility pole on that site. We have, from a third party, have obtained information indicating that that is specifically for that project and is not some other utility project that's crossing that property. So based on that, that's the basis for making that motion, that they have initiated work or construction on the site without providing any plans as required by the NFPA. That's specifically NFPA 1.7. Sorry, this is I'll restate the motion because I'm rambling on now. Specifically 1.7.12.2 says the plans that shall be submitted prior to construction, shall be submitted to the AHJ prior to construction unless otherwise permitted under some other section which talks about essentially 1 and 2 family dwellings. It doesn't apply to this, so. And also, as I mentioned earlier, on that same basis, a stop work order was issued under the county's floodplain ordinance last week. I believe that was delivered on Friday. So I'm going to restate the motion. I make a motion that the County Commissioners Court as the AHJ issue a stop work order to the Rogers Draw, all parties involved with the Rogers Draw construction pursuant to NFPA 1.7.15 for work being done contrary to the code. Okay, there's a motion and a second. Any discussion from the Commissioners Court? Legal?
So you mentioned 1.7.12.2. Which one are we issuing under?
It's being issued under 1.7.15, which gives the AHJ authority to issue stop work orders under 3 different conditions. One of those conditions is when work is being done contrary to the provisions of this code, meaning the NFPA 1. The section that my motion is based upon is 1.7.12.2, which requires that plans be submitted prior to construction. And as everybody's aware, we have not received any plans to date. And so 1.7.12.2 is the code that they're working contrary to. 1.7.15 is the section that gives the authority to issue the stop work order because of that action that's contrary to the code. Work is contrary to the code.
So what's our mechanism of enforcement? If the sheriff department, if they continue to construct?
Well, we issue, if we issue the notice that we notified, I believe the fire marshal needs to post notice on the property itself. If there's failure to comply, then we move into enforcement remedies, which could be penalties, monetary penalties, and then additionally, we would seek injunctive relief if we needed to. We already have pending litigation on this, so injunctive relief would probably be maybe even faster or easier to get court input on than if we were initiating that from ground zero. Yes, ma'am.
We laid out a fine penalty program with Sarah Neal months ago. So you already have that information on what the penalty process is.
And then I will also, it's sort of unrelated to my motion, but under the county floodplain ordinance, which relates back to the water code, that also gives us specific injunctive relief if needed for enforcement. So we have two avenues now that I think would lead us to potential relief, judicial relief if needed, if we don't get compliance with the proposed order. And typically it can be both. It can be, the penalties and what are set forth in the NFPA plus additional relief outside of that. Any other questions or discussion on the motion? All right, all in favor, say aye.
Aye.
Aye. Aye. Any opposed? All right, that motion carries. Ms. Neal, we will need to get with Fire Marshal and execute the delivery of that ASAP. All right, any other discussion? Yes, ma'am.
I have a question, because I'm from Wyburn, we live right there at all of this. And LCRA was the one that was actively putting that pole up. And I can tell you, there's no one from the Peregrine or anybody coming in and out of that gate. So putting something on that old little piece of thing up there that they have is not gonna stop them from doing anything. And I think LCRA should be aware, be made perfectly aware that, that there is a stop order on that property, because I think that they're, that they want these things, to a certain extent. But that they need to be aware that that's a stop order. Everybody needs to be aware of it. I don't know how you can do that, but it's got to be something that's made aware to them, because putting it up on a little piece of board out there that they have up with all these permits and whatever little notifications that they have, they get rained on, you can't read them, and right now, we haven't had any helicopters flying over our land recently, so I don't think that they're coming around.
Okay. Yes, ma'am. I mean, maybe there's a misunderstanding. The code requires delivery of the notice in multiple ways, so they'll be served, traditional methods, certified mail. I'm sure we'll email copies to everybody we have contacts with. In addition to that, we will need to post a notice at the site. That's just so if there's, lower level subcontractors or something that appear and they don't have that information, they know that there's a stop work order in place. So it'll be a holistic approach to notify them, not just putting something up at the site. So I didn't, maybe that was just a misunderstanding the way that I presented it.
So if I drive by, like we have for the last 2 weeks, and watch LCRA put up this massive pole, who should I call?
So we have put I've asked IT to post I've created a form on the county best page that you can go and submit any activity you see that you think is suspicious, or you have concerns about environmental, contractor misconduct, anything related to the best, you can submit that form on the county's best page. There'll be a form up there. Additionally, I'm going to put just to call my office. My office sort of serves as the main number for the courthouse. If it's an emergency or after hours, you need to call 911. If it's after hours, maybe non-emergency, you can call the non-emergency dispatch number. So that's all going to be on the best page. That's one of the things that we have asked for help with from the community is notifying us. The Harper site is a little more visible, but the Marshall Springs project is less visible, and so I'm trying to create an avenue for anybody in the area that may see something to be able to report that, and create a record of it, so we have that to follow up. So that's the mechanism. We're trying to put everything we can on the county's best information page. I know we have 2 websites right now. We're trying to keep them sort of mirroring each other, but we're very soon, we're going to be shifting over only to the one new website, so everything will be on there. Okay.
Thank you.
Judge, I think a more pointed question, excuse me, is if you go out to date and LCRA is doing work, why don't you simply send out a county official and say, stop work?
So that's what the fire marshal will be doing.
Well,
Yes.
So
In real time, in real time?
Yes, yes.
the big thing is that LCRA interconnection agreement. It gives you a timeline of who was supposed to do what when. And I think a letter from Sarah Neal advising them that this has been issued, that it stops their agreement, that you issue that.
Right. Yeah, I mean, I expect that we will, LCRA may be.
And you copy the PUC and ERCOT.
Right.
Judge?
Yes, ma'am. I'm sorry, yes, sir.
It's okay. David Nash. So in that GIS report, I ask you guys to look that up. It's easy to find. It's got tons of information. But one of the columns has to do with the transmission service provider, which is LCRA. And they were given, it's kind of a yes/no type answer in the box, and the answer is yes to been given financial assurance to do that work. Okay, so I want you to understand there's a distinction on what LCRA is doing versus what the BESS entity is doing as far as the construction goes. I don't know what the terms of that easement, it's an easement that's put in there. There could be some terms in there that tie it to construction or whatever. I just want to know if there's a distinction.
Okay. Yes, sir, and indeed, I think we're all aware that LCRA is the one that, it says LCRA on the pole. But it's on private property, it's on the work site, it's not in the right of way, it's not in the utility right of way or anything like that, as far as we know. And so, I think the burden is on them to show that it's not, not in violation, as opposed to us trying to assume that it's being done, in some sort of, whatever justification they have. I mean, we're putting the burden on them to come back and show us that they think it's okay, and then we'll discuss.
Okay, thanks.
Okay, any other discussion on that item on the Commissioner's Court? Okay, we'll move to item number 4, which is discuss the Marshall Springs Solar Complex and Battery Energy Storage Facility, and discuss taking any action related to that project. I do not have anything to propose as far as action on that item today. Still waiting to hear some response from Ampere, other than the email we received, which just stated they were in sort of I don't know what they call it, but they're claiming they're not even into development phase yet. But waiting to get an official response to the letter that was communicated from the Commissioner's Court related to ceasing or not commencing any construction or development activity until permits are issued. Anything else that the Commissioners want to offer or discuss related to that project?
I have one more question about that, Judge. Don't hate me, sorry. The solar and the BESS facilities, Ampere has specifically stated that they're not the ones handling the BESS facility. So I know that we've sent a letter to Ampere. Do we, because I don't know personally, do we know who is actually specifically responsible? I thought I had misspoken before when I thought it was the Rogers Draw because I miscommunicated. Do we know specifically the company responsible for the BESS portion? And have they also been notified? And can you guys share with us who that is? Because we don't know.
I'm not aware of any contact we've had from any company other than Ampere on the project. I do know they've got separate LLCs or other entities set up for both phases. I don't know if that's still under Ampere's umbrella or somebody else, but I'm not aware of any other corporate entity that's involved with the project that I've received any communication from or anything like that.
Isn't that in the development permit or the paperwork that they filled out, I think Ampere says they have two separate.
Right.
Yeah.
Yeah, my suspicion, at least at this point, is that they're both under the Ampere sort of corporate umbrella. We have not, I'm not aware of any communication from any other party that's working on the development of that. You know, I guess it's possible a third party could come in and want to develop that portion of the project, or maybe they'll sell it off or something, I don't know. But short answer is we don't have any other, I don't have any other information of any other party that's involved at this time.
Thank you, because we all know, right, they play their little shell game and change the names, and we just recently found out that several of them are now changing the projects on ERCOT website. They're now listing a lot of these best sites as other now to try and fly under the radar to not get busted for what they actually are too.
Okay, so there will be no action on item number 4. We do have an executive session set up for the meeting. I don't anticipate there being any action related to that. The purpose of that is primarily to inform the court as a whole concerning the status of the hearing that was held last week and litigation moving forward. It's not, they're welcome to stay, but I don't anticipate there being any action coming out of that executive session today. I'm just letting make everybody aware of that ahead of time. One of the difficulties with the Open Meetings Act is that we can't all sit in a room and discuss this except for in the public meeting context. And so for us all to discuss as a body, sort of get understanding and reports on pending litigation and strategies moving forward and decisions we may need to make related to that, we have to do an executive session. So that's the purpose of today's executive session, is really just to discuss status of what's going on. Even at the hearing, we did not have we had to pick who was going to attend because we didn't want to have a quorum at the hearing. So some of our commissioners didn't have an opportunity to even attend the hearing to see what happened. So that's just the nature of how we're working under the Open Meetings Act. That's all the items we have on the agenda today related to the battery energy storage projects and the solar complex in the county. Again, we'll take a 5-minute break. If y'all want to step out of the meeting, you're welcome to do so. It's a public meeting. You can remain for the remainder if you want to. Otherwise, have a good day. Thank you. It's 10:40 a.m. We're going to do a recess. With that Bible book. And then you get away with the camera a year later.
Good.
You guys got this guy right here. Sorry, we're talking way too much today. Sorry. A lot of coffee and all that.
Like I was missed text this morning.
Looks like he's gonna be coming out again here pretty soon after sounds like I'll be that accomplish my mission. Thank you for that info. I'm gonna check that out.
Between the camera and
And so, guys, since you're like, I'm just not trying to be like coming after you all. Like, I was just, it is. Yeah, it does. Yeah, I really do wish I was like, I'm not trying to fight with you, but like, I know it can get heated. I know all this stuff is stressful for everybody, but I know that all you guys are under just more stress than we are. So good luck. I appreciate y'all. I just want to continue to reiterate that. In no way trying to be towards any of y'all.
Police on the building. Who's gonna stay? I think it's 6 months. Did 1 year. We actually asked them to vote and all one stay.
Exactly. Anyway, we'll see you there.
Scott, you have a minute?
Yeah, so I talked on the phone, but it's been a while since I've seen you. A couple of times, in passing, for a minute or two, I got a new phone. And when I'm at home, it wants me to plug in a code and send it to you today, but it never works. And when I come to the office, my email's down with my phone, but as soon as I leave the office,